Jagga, a fifth-year law student from University of Petroleum and Energy Studies, pursuing BCom LLB in taxation laws. So nowadays I'm a legal intern with LEXIS and Company. So today for our topic is section 89 of the Code of Civil Procedure 1908. So let's discuss the section 89 of CPC. So let's start with this topic. So section 89 of the CPC 1908 gives a power to a court to refer the matter to the alternate dispute resolution method, which is a out of court settlement. So when it appears to the court that the exit an element of the settlement which may be acceptable by the parties, then the court may formulate such settlement or propose a settlement and refer the parties to an alternate method, which is alternate dispute resolution. Okay, so this dispute such as the arbitration, conciliation, lok adalat or mediation. Okay, so the contention from the behind this section was quite apparent, as most of the developing countries has already adopted the alternative dispute resolution method. So the method adopted by them were provided to be the successful to the contention over the 90%. Okay, so let us discuss what are the interpretation of the section 89 of the CPC. So in section 89 there is a word used may and shall, which need to be clarified in order to settle any doubt or possible conflicts that may be arises with a regard to the interpretation of the provisions. So the court shall formulate the terms of the settlement comes earlier, and word may is used in the later of the part of the provision. Okay, so section 89 does not impose a mandatory duty upon a court to refer the parties to the arbitration, conciliation, mediation, mainly because it is possible to resort to such method in a particular cases. So the word shall also be used in the order 10 of the CPC and is observed that the court is under the compulsion to refer the parties to the alternate dispute resolution. Okay, so let us discuss the very important concept of section 89, which is the constitutionality validity of section 89. So constitutional validity of the section 89 was challenged before the Supreme Court of the India by the Salim Advocate Bar Association on the ground of the arbitrariness. So there was a series of the arguments on the following issues. So first issue on the argument is that there was no explanation on how the provision should be implemented. Second issue was no guideline concerning which case to be referred for the settlement of the court. Second issue is how to refer the disputes. Third one is what would be the management formula regarding the referring the dispute to the alternate dispute. And last issue in the dispute is what rule and regulations should be followed while taking the alternate dispute resolution under section 89. So let us discuss what are the conclusion for this topic is for today's topic, that the judiciary is already overburdened with the cases, and because of this there is a delay in the disposal of the cases, okay, which threaten the justice. Okay, so when we insert of the section 89, the court can suggest the alternate dispute resolution method to the parties where there is no arbitration argument between the parties. So it is very helpful for both the court as well and the parties as well. And this method is a fast and rapid method of the judiciary. So the party can avoid a litigation and choose the alternate dispute resolution for resolving the disputes. Okay, so that was it for today's. So I hope you understood each and every concept of this lecture. If you have any doubt regarding anything, please feel free to comment in the comment box. Your answer should be given as soon as possible.